Today and welcome to our next episode of Football Transfer Markets, and today we are going to cover Cyprus. Our guest will be Loisos Hagidimitriou, who is an international sports lawyer and the founder of Loisos Hagidimitriou and Associates LLC. Luis has an extensive background in disciplinary matters, and not only, he is also legal counsel of the Players Union in Cyprus. And now Loisos will take us on a journey to Cypriot football domestic regulations. So let's begin. Loisos, thank you for being here. Thank you for accepting my invitation to have this podcast, because we know each other since 2018 from a case that we were just covering before this podcast. So, Luis, just before starting, I think you find this project interesting because nobody speaks about domestic regulations. I don't know why everybody speaks about international ones, but to be honest, when you just dive a little bit deeper, domestic regulations are quite interesting because they differ from one to another, and you find completely different regulations there. So today we want to cover three topics. First is domestic training compensation system. Second one is common transfer fee types used in domestic transfers if the transfers are being organized against transfer fees or against compensation. And the third one is so-called standard contract form, usually recommended or enforced by the local FA or the league, because there are some countries which enforce it. They do not recommend, they enforce it. And finally, the fourth question is absolutely up to you. What you would like to speak about the domestic football matters, legal, not legal. So it's up to you. So let's start about domestic training compensation system, how it operates in Cyprus. How is it going?
So until a few years ago, we had a very problematic internal regulatory system. In the past, the regulation said that training compensation would be payable when a player signed his first employment contract, or when a professional was signing with another club again as a professional until the age of 23. What was kind of unique in Cyprus was the fact that the amount of training compensation was calculated in relation to the player's remuneration under his new contract. So you can imagine that this system was open to abuse, because many clubs were signing contracts and submitting them to the association, showing that the player was receiving a very low salary in order to avoid paying the appropriate training compensation, whilst they had also at the same time private agreements with the players stipulating the actual salary that they had agreed to pay him.
You know, the first thing which is worth to cover immediately at the moment is if the player was transferred internationally at the first case and then being transferred domestically at the second place. We know that RSTP clearly says that the clubs are obliged to upload into TMS correct data. So what do you think? If the club also signs this kind of private agreement, then refuses to register it properly, even at the first transfer, because if the club then decides, I don't know, let's say the club has some concerns related to salary at the later stage, if they commit something like this, do you think, is it subject to disciplinary proceedings within this article of RSTP or not, if you do not provide the private contract?
If FIFA finds out that a club has not uploaded the correct contract on TMS, it is certainly a disciplinary offense. But this is about FIFA international transfers.
Yes. So now I'm going to continue the question, because you have extensive disciplinary experience. What would you do if the same question would arise domestically there is no any, without prejudice, okay, to any existing proceedings or whatever. So your vision as a from the disciplinary perspective locally, domestically, how would you describe if, because I'm sure in any case there will be some article that if the club submits wrong data or something to FA, it's a disciplinary violation. This is some kind of a basic rule. So what do you think from the domestic perspective? Is this a violation or not?
Of course, it is certainly a violation. And I would say that it can also uh, raise criminal issues as well, apart from disciplinary. Okay, but of course, the association will not deal with criminal issues, but it is something that the club needs to have in mind if it is going to upload contracts that do not represent the reality. Because under our national law, when you present a document which uh, when you submit a document which presents a picture which is not true, then this is forgery.
So even if two parties signed it, it's being assessed as a forgery, even if two parties signed it.
Even if the two parties sign it, it consists forgery if they use it to show to someone else a picture which is not true. So both of the sides will be liable for forgery, both the player and the club.
It's very interesting because, let's say, there is a small contradiction between the will of the parties and the public regulation. Like the government, I think that the government looks at this as two parties organized the conspiracy against the government, something like this.
Exactly. Because you need to remember, Ashot, that from the moment that the contract is submitted showing the wrong remuneration of the player, it means that the social security contributions and the tax which is paid are based on a fake contract.
So the criminal element in this case is going to be connected with tax evasion or forgery, because those are two different
Both of them.
charges.
Both of them.
Both of them. Okay. So yeah, I can already understand what kind of concern there was that 3 years ago the system was changed. So what is the system now? How is it being
So
organized?
the system that we are now using is almost exactly identical to the RSTP. To be honest with you, I am the one who prepared the regulations and proposed them to the association, and the association accepted almost all of them, with only one differentiation, which is important in my opinion. And what the association did not accept is to deprive a club that was not interested in a player and did not want to keep him in its team, to deprive that club from requesting training conversation from the players in your club. So uh, this this uh, this provision is similar to the exception for
Of European Union.
uh, yes, associations in the European Union. I am sure you are aware of that article. So the association did not accept this provision, and it is creating a lot of issues, to be honest. And we are now trying to change it. The association is now willing to discuss this, and within the coming weeks, we will have a meeting with them to amend this regulation, this part of the regulation, because it is creating problems not to the good players. The good players that are considered talents, they don't have a problem with this because they are always the clubs are always willing to invest in them and pay for them. It's creating problems to uh, medium level and low level.
To develop their career further.
Yes.
So just for the sake, maybe this will be interesting for you because years ago I was also I was also the one who proposed an amendment to the current system in my jurisdiction, and we came to, let's say, golden middle with the FA by discussions and made the following system, which operates till now. Maybe it will be useful. I don't know. So we decided to fix this problem in the following way. We made two thresholds. The first threshold is high amount, and the new club is obliged to pay by the same way, more or less, okay, without diving into peculiarities, in the same way as RSTP regulates. The second threshold stipulates a lower amount, much lower amount, for the same first, second, third, fourth categories, okay? So what is the difference? If the club is not interested in the services of the player anymore, the club just issues a written certificate to the new club that the former club is not interested in the services, and the calculation is being done by the much lower amount. So this helps both to comply with the contribution more or less done for the development of the player, and not to intervene with the player's further development.
Okay.
Up till this moment, it operates, but there are some concerns about the amount because inflation, and many years have elapsed. So this is also a good
Okay.
system to consider. Maybe why not?
But what if the club did not accept that it was no longer interested in the player? What happens in these cases?
Well, let's say the club. I'm just right now. I'm depicting a real life example.
Okay.
So the player was good player in the former club, and the club really is interested in the services of the player. Indeed, like genuine interest. But at the end of the day, the player and the club cannot come to a conclusion or agreement for the player's remuneration, right? The player asks much higher salary than the club can accept. So in this case, player decides to leave this club, correct? Correct.
Yeah.
The player leaves, but the club at the same way says to the new club, I was interested in the services of the player. So I'm not going to issue the certificate that I'm not interested because I'm still interested. It's just a matter of coming into agreement with the salary. So please pay me the full contribution, which I indeed made for the player's development. So it's up to just a certificate being issued or not. One thing that concerns me is that the electronic registration system automatically calculates the amount, and our FA doesn't accept waivers.
Brilliant. Okay.
Yes. I mean, let's say there is no strict regulation on that, like depriving waiver. But in practice, practically speaking, I have never encountered that any waiver was being accepted because it's like an automatic process. So if you don't have the payment proof of payment, you cannot register the player. And there is no case that one of the clubs appealed this, etc., etc. So it's being counterbalanced like this.
Well, this system in Cyprus is going to be against the national law, the European law, because if you deny registering the player because the two clubs cannot reach a solution on training compensation, it means that you are in breach of an employee's right to free movement, to a worker's right of free movement.
The system says that it's not the player who must pay the amount; it's the club, is the new club. So the new club will just not come into an employment agreement with the player in this. So they do the diligence in advance.
Okay.
Something like this. So what about any other peculiarities?
So let me explain to you how the current regulation work actually. Basically, we follow the same principles as FIFA. One of the differences is that the training of the player for which the club is entitled to be paid training compensation is up to the 18th year of the player. So FIFA allows training compensation payable for training up to the age of 21, for transfers made until the age of 23. In Cyprus,
So you want to tell me that Cyprus Association decided to stipulate that the player's development establishment, because FIFA says established player, in the sense that the player's training ends at 18 years old, not 21.
correct, yes. Nevertheless, training compensation is payable for transfers up to the age of 23. But
Yeah.
payments stop at the season where the player turned 18. Okay.
Mm.
Now, this is another difference with the current FIFA regulation because uh, the regulations that were made in Cyprus were before 2020 when FIFA put in place the calendar year. Okay, if you remember in the
Mhm.
past, FIFA was estimating training compensation based on seasons where the player turned 12, 13, 14, up to 23. So the system in Cyprus is still based on seasons. So payments begin from the season where the player turned 12 until the season when the player turned 18. So we have not yet adopted in Cyprus the calendar year uh, system, which is now in place at FIFA.
And is there any justification by a circular letter or something why the local FA decided to find the age of 18 as an age that the player ends its development? I have my own opinion. I think that do you have a competition of U19, U20, U21?
Yes, that is.
Then the question is more than legitimate about justification because more or less the age of 21 is related to the competitions being organized in organized football. Yes, so there are many countries which have U21. So that's the reason that players' development and training ends at 21. But
In Cyprus, we do not have U20, we have U19.
U19.
Yeah.
And this U19 corresponds to the 18 years of the player becoming 18
Yes.
years old.
Yes.
Then it's justified. This is the justification in this case, because if there is no other youth competitions, then the player is being considered established. I think that's the logic. I don't think there are other justifications.
This had been in place for many years, to be honest, and nobody challenged it or tried to change. So,
Well, it's more or less like a sporting criteria rather than legal criteria. But I think that the only justification is that because like cutting 3 years away without any justification would be at least awkward to say. So is there anything specific about solidarity contribution also, or it's just a regular
mm,
one?
what is specific is that when we were agreeing on the new regulations for solidarity contribution, we also added a provision for solidarity contribution in national transfer because until then there was no provision, there was no obligation in Cyprus to pay solidarity contribution in domestic transfers, in national transfers. But now we have added it and it's the same like FIFA, it's 5% for players from 12 until 23.
By the way, recently I had another podcast with Hrvoje Čabraja, the head of legal of Lokomotiva Zagreb, and when discussing the same topic, he told me very interesting regulation. In Croatia, they have solidarity within a solidarity. So what does it mean? Apart 5%, there is also 1%, which the former club, not the new club, the former club deducts from the transfer fee and pays to the local association which participated in the player's development. You see, very interesting one. Like twofold solidarities. The new club pays the former one 5%, but the former club in turn also must pay 1% to the local association. Quite interesting.
Okay, very
So,
interesting.
yeah, so
Well,
interesting.
in Croatia, their system is working pretty well when it comes to talents.
Well, that was the topic about that. Croatia is one of the countries which may be considered as exporting country of the players. So they have much more advanced solidarity system. So makes sense. Absolutely makes sense. So I think we covered the first question. So let's jump to the second one, which is common transfer fee types used in the domestic market. If there are some other, let's say, approaches related to the transfers between the Cyprus club and the foreign club. Also, let's speak about this.
Okay, to be honest, Cyprus is a small place. We're not really an exporting country of footballers. We have not had a lot of cases where footballers are signing to foreign clubs and then going to even high quality foreign clubs. Uh, but in the cases like the one you described, what we have in Cyprus, the most often uh, scheme that is used is buyout clauses. What is very common in Cyprus is the fact that clubs are always trying to prevent young talents from signing to another Cyprus club. So it is very common to see buyout clauses restricted to international transfers.
Okay.
What we have
So,
also
just for the sake of comparison, we may say that it's equal to a rule where the club and the player decide to stipulate a clause when the player receives an offer from abroad, then he can go.
yes, because there are many clubs in Cyprus. Most of the clubs in Cyprus, they are very cautious on not losing a good player to another club.
And just a small adjusting question: buyout clause or liquidated damages?
No, okay. As you are aware of, these two clauses are very, very different. Buyout clause is a clause that will allow the player to sign with a new club if he finds such a club, and he will not have any liabilities towards his former club. Whereas a liquidated damages clause is nothing more than an agreement between the parties of the compensation that is going to be payable in case of breach of contract. So, as you know, if a player uses if a clause is badly worded and it is interpreted as a liquidated damages clause, then both the player and his new club will be liable for breach of contract if the former club seeks resource before the FIFA and DRC.
Put differently, sporting sanctions. The difference is in
Yes.
sporting sanctions.
Yes.
But also, I ask because there are jurisdictions where, depending on the structure, if it's a buyout or liquidated damage, actually you can have difference in tax regulation. For instance, there are jurisdictions when the government says about buyout clause, okay, not the liquidated damage. In case of buyout, if you have the buyout clause, but you come to a mutual agreement to terminate without compensation, the government is entitled to come and say, great that you didn't exercise your right to claim the amount, but not from my pocket. So the government has loss here in terms of the unpaid taxes. So come and pay. So there are some jurisdictions that the clubs intentionally avoid to use buyout clauses and stick with the liquidated damage clauses. So which one is more popular in Cyprus? Like about the wording? I know that the wording might differ, but which you saw personally?
Yes. The one that is used, or at least it is intended to be used in Cyprus, is a buyout clause, not the liquidated damages clause. Yeah, but of course, sometimes the wording may interpret the clauses as a liquid damages and a buyout clause, even if that was not the real intention of the parties.
Yeah, so it's very, very straightforward, and I understood. So.
But from what you said now, Ashota, it came to my mind a case that we had a few years ago, where it shows the difference between national regulations and FIFA regulations. So what had happened was that a Brazilian player was registered with a club in Cyprus. He was doing very well, and the player was interested to go to a bigger club in Cyprus. There was a club that was interested in the player, so the player unfortunately got wrong legal advice, and he terminated his contract with his former club without just cause. Okay, and he signed with a new club. So the former club went to the FIFA and DRC. They filed a claim there against the player and his new club. Okay, so there was international dimension in the dispute, so the former club could go to FIFA. At the at a very late stage, the player contacted me, and I advised him that uh, the case is clear. You're gonna have a problem. You terminate without just cause. FIFA will not only order you to pay compensation, but most probably they will also impose fine sporting sanctions on you. So I told them that we should give a shot. We were still entitled to file a second round of submissions. Okay, so I told him what we should do is that we should try to bring the case to Cyprus because the Cyprus regulations do not provide for sporting sanctions, and they also do not provide for for joint and several liability of the new club.
And just a small question: did the player file a counterclaim in this case or not? Because I'm going to ask about Forum Shuttle.
No, he did not file a counterclaim here. He just filed in defense. So in the second round of submissions, we made extensive argumentation on jurisdiction because the player's contract had a clause saying that in case of a dispute, the only competent body to hear the dispute will be the Cyprus FA. Okay,
Okay.
so
NDRC. You mean
the,
NDRC?
the NDRC, yeah. So we made extensive argumentation on this issue, and uh, we were lucky because in a few days, the 2 years would have passed from the day when the dispute occurred.
Prescription period. You speak
Yes,
about prescription.
yes. And if in case FIFA would accept our argumentation, the former club would not be able to file a claim to the NDRC because it would be time barred. So one day before the dispute would be time barred for Cyprus, because FIFA had not yet decided, the club, being afraid of not losing at FIFA and also losing the right to leave Cyprus, they filed a claim at the NDRC. So immediately, the claim at FIFA was considered as withdrawn since a new claim was filed in Cyprus, and the decision the player lost, of course, because it was a clear case. But what the player said was that there was only a monetary decision against him. There were no sporting sanctions, and his new club was not ordered to pay anything. So we had an agreement with the new club in advance that if we succeed having the case coming back to Cyprus, then you will cover the player's compensation, the compensation that he will be ordered to pay. So this
Well, what you just said can be summarized as a very good and positive outcome, considering what you had at hand at the moment.
yes, because we managed to take advantage of the differences in the national regulations from the FIFA regulations. So even though the player should have been imposed sporting sanctions together with the compensation, he managed to get away with the sporting sanctions and pay only the compensation, which was of course covered by his new club, not the player.
Okay, so what about conditional fees or sell-on fees? Are they popular in transfer agreements within domestic market?
Yes,
or not?
yes, they are popular. They are very popular. We are using them a lot, both sell-on fees and also conditional payment clauses.
And upon your practice, the conditional fees that you saw, or even now, if they are popular, you see probably even this summer, like to what conditions they are interconnected with?
Mostly, they are conditional upon sporting successes of the team of the player or even the player. For example, one of the most usual clauses is that if the player plays in a minimum number of matches, then the new club will have to pay an additional amount to the previous club. Also, if your player is an attacker, for example, you might see a clause saying that if the player scores a number of goals or if he makes a number of assists, then the new club will have to pay an additional amount to the previous club.
And I suppose the same goes for goalkeepers for clean sheet matches, right?
Exactly. Yeah, exactly. But Ashot, a few weeks ago, I was examining a contract for Germany, and I was very, very surprised because that contract had almost 8 pages of conditional payments. It was the first time that I was seeing such a thing.
That's what I was thinking about. And we had such discussion recently that day by day we see more and more data scientists being part of football industry and having a crucial role. And if you ask me, my personal opinion is that it's very good. It's very good because their profession helps the sports a lot. So nowadays, services like Y Scouts and many other services which collect data of the player's performance. There are many GPS trackers,
Yeah.
many equipments. This data generating actually can be used to connect bonuses or payments with the player's performance. And as you said, it can be 8 pages. Depends on what we are speaking about and what conditions we are covering about.
And I think that it is a good method because it also gives the player incentive. So
Yeah.
I think that this kind of conditional payments in a contract, they can be used in a way to make sure that the player will always have in mind to perform as best as possible instead
And
of
buyback options?
dreams. Sorry,
Buyback options, are they popular or not?
buying back.
But buyback, when the club releases the player but stipulates that it has, as a former club, it has a priority to buy the registration rights back.
There are some clauses there are a few cases where these kind of clauses are inserted in a contract, but of course, as I'm sure you know, these clauses are kind of illegal, illegitimate, because uh, at least in Cyprus, under the national and the European law, you cannot force a player to go and work somewhere where he did not want. And a few years ago, we had a very, very interesting case. It was not a buying back clause, but it was with the previous training compensation regulations. So what those regulations were saying were that when a player is an amateur and he's registered with a club, then the club has the right for the 3 months after the player becomes 18, the club has the right to propose him an employment contract. And the player is obliged to accept that employment contract. So we had a case with the two traditionally biggest clubs in Cyprus. The player was registered with one club and he wanted to sign an employment contract after he had turned 18 with the other club. The club that was training the player had indeed proposed him to sign an employment contract as per the regulation. So as the regulations were, the player had no option than to accept to sign an employment contract with that club. Nevertheless, the new club submitted an application to register the player. The CFA did not accept to sign the player, so the case went to the NDRC. Both the NDRC and its appeal body decided that the player could not be forced to sign an employment contract with the club if he did not want to sign with that club. And the decision was based both on the Constitution of Cyprus, which says that everybody has the right to work where he wants. You cannot force someone to work somewhere where he does not want to work, but also on the EU law. Coming back to buying back clauses, if you have such kind of a clause in a contract, then that clause cannot really be activated or triggered in the future, because if the player does not want to sign with you, then you cannot force him to sign with you.
Yeah, so I also find this regulation, the buyback scheme, a little bit controversial, but not only connected with the freedom of movement, but also within the same framework of RSTP in terms of third-party influence, TPI. Because if you are connecting this, if you are making binding upon the new club such condition, where more or less you have, let's say, an influence on his sports, not sports performance, but the management. So you can actually interfere in the sporting planning of the club in future. So it depends how strict FIFA's disciplinary committee is going to apply the rule of TPI in connection with the buyback options. So this is my vision. I think we also covered the second question, and let's jump to the third one: standard contract form offered or recommended or enforced by the league, and the league, I mean the top tier league, or the FA. So how it's being organized in Cyprus?
Okay, so in Cyprus, we have a standard contract in place. Okay, but it has some sort of history behind it. So in November 2014, we had a meeting in Cyprus under the social dialogue, where UEFA, FIFA, ECA, World Leagues, and the association were involved, trying to find, to adopt some minimum requirements in professional contracts, which were drafted in a memorandum between UEFA, FIFA, etc. So in that meeting, it was agreed by the association that a standard contract would be adopted in Cyprus. So we prepared the standard contract. To be honest, I was the one who prepared it under my capacity as the legal counsel of the Players Union. So we prepared a draft of the standard contract. We sent it to the association. The association sent it to the clubs to make their comments. As usual, the clubs did not even respond to the association. The association came back with a few suggestions. At the end of the day, we finalized a draft. And since January 2015, we have a standard contract in place, which is mandatory. The association will not accept to register a player if a standard contract is not submitted for that player. Unfortunately, in the first summer of the COVID, summer of 2020, there were huge disputes, disagreements between the association and the players' union. It was on whether players were allowed to be paid when the championship, when the competition was suspended due to COVID. And following these disputes, the association started making unilateral amendments on the standard contract. So the standard contract, which is in place today, is not something to which both sides, players and the association, have agreed to. But nevertheless, it is still mandatory to be used.
Right now, I'm going to inform you in advance that at this very second, we are going to have very interesting argumentation against each other, because the club's lawyer started to speak inside me, And yeah. So first things first, I would like to know, obviously I know the answer, I anticipate the answer in advance, but I want you to say it. Does the FA undertake the liability for the validity of the standard contract between the relations of the club and the player?
What do you mean undertake the liability?
I mean, if you as an FA enforce onto me as a club a contract, correct? And maybe the will of the parties between me and the player, we have other will, true and common intention within the sense of Article 18 of Swiss Code of Obligations. We have different will, let's say, but you say as an FA, you say, no, you must sign this wording that I drafted for you, but we together with the player do not want it. So my question is, if there is a dispute related to the wording of the contract which was enforced onto us, within this sense, does the FA undertake liability for the consequences of it or not?
Very good question, Ashot. First of all, until today, no club in Cyprus protested about the standard contract or its wording. So we have not yet had any issue between clubs and the association. But nevertheless, one of the amendments which the association made in the standard contract resulted in actually making a legitimate clause, turning it into illegitimate. Okay, and it's regarding the right of the parties to terminate the contract in case of relegation. So the initial contract which we made was giving the right to both parties in case the club would relegate, and both parties would have the right to terminate within 15 days after the championship had ended. In 2020, the association amended this regulation and restricted this right only to clubs. So there is no reciprocity. So the clause now is totally illegitimate. If a case goes to FIFA, the club will be ordered to pay compensation. Okay.
Well, again, the club former in-house club lawyer speaks inside me. But if you ask me, this is my personal opinion. It can be wrong. I don't claim to be 100% correct, but I find this kind of approach, first of all, creating an unequal bargaining power. This is the first part. The second part is abuse of dominant position within the market.
You mean for the association making the
Yes. Because if I, for instance, like, look, I have my experience is a little bit international with clubs, because I also have I work with clubs from abroad, from different jurisdictions, and I can say that I saw some jurisdictions when the league enforces the contract. They say, no, guys, this is mandatory. Like, I'm not going to accept even a comma right or left from this part. But they actually are flexible, and they stipulate, like Article 9, other conditions. So in these other conditions, you are really entitled to even regulate the rights and obligations of the parties. So I mean,
so finish and I will.
Yeah, so you can stipulate about sporting hierarchy, and many other obligations like medical insurance or whatever. But for instance, like in Armenian jurisdiction, and I'm completely fine with it. I like what the FA did at this related to this part. We have a recommendation contract, like it's stipulated in the domestic RSTP, and you as a club are entitled either to follow it or not. But in the same way as the FIFA RSTP also has the Article 18 of special provisions related to employment, local RSTP also has the mandatory provisions which you must comply with. So if you comply with this requirements as a minimum requirement, okay, then the rest is up to you. Draft it however you want. But if the FA gives me a contract that says, as a club, that's it. It's over. You cannot deviate from that. I find this a little bit abusive, actually.
Okay. I do not entirely disagree with you, but I do not also agree with you, because out of my experience, not only in Cyprus but internationally, it is good to have a standard contract, because previously there was a mess. You would get any kind of contracts, even by the same club. Okay, it is very good to have a standard contract with a certain number of provisions that cannot be amended, that are codified in that contract, because the relationship between players and clubs are uniform. Nevertheless, this does not mean that having a standard contract does not give the right to the parties to agree on something additional. They always have this right, and they have it in Cyprus as well. So what you have in Cyprus is that you can agree to any clause in addition to the clauses contained in the standard contract, provided that these additional clauses are not contradictory to the ones of the standard contract.
That's absolutely normal. Absolutely normal. I agree.
So what to do in Cyprus, and have in mind that the standard contract that we prepared and we have in place is not something that was a creation of Cyprus football. I mean, we were guided by the Premier League standard contract. And one of the reasons why we took guidance from the Premier League is not only because it's a top football globally, but also because the legal system in Cyprus is Anglo-Saxon legal system, because Cyprus used to be a British colony.
So it's common law.
Yes. So legally wise, it was also the correct thing to do, to draw guidance from the Premier League standard contract. Okay, we did not copy it, of course, but we adopted many of its parts. So what you have now in Cyprus, we have the standard contract is made up of two different documents. One document is 10, 11 pages, and it's the standard clauses that cannot be amended in any way. Those are mandatory. Okay. And they include the minimum requirements, which are in the memorandum of understanding between FIFA, UEFA, and European Union.
Social dialogue, yeah.
Yeah. Plus some additional clauses, provisions to which both sides have agreed together with the association. So this is the one part, the codified standard contract, which cannot change. And then you have another part, which is 1.5 pages only. Okay, and that is a part where each contract, that is where the club and the player will write down the duration of the employment, the remuneration, the bonuses, and any special clauses that they want to include in their employment relationship.
Just a small question. Does the standard employment contract have a reference to the internal regulations of the club? Like disciplinary matters are going to be regulated by internal regulations of the club or something like this?
Of course, yes, it has a reference saying that.
Okay, so rights and obligations will be regulated by the disciplinary regulations, the internal disciplinary regulations of the club.
As long as they are not contradictory to the standard contract.
Yeah. Or if somebody doesn't decide to challenge the entire standard form, which was adopted upon the social dialogue, but maybe some club decides to even appeal this. So it can happen, but it's interesting. It's high pressure on clubs, in-house lawyers, but I am sure they will have a workaround.
Well, believe me, both clubs and the association were very happy.
Seriously,
when we adopted it, because imagine the association having to check in the summer transfer, having to check, I don't know, 200 contracts, and they were getting different contracts. Every contract was different. Now they are all the same. And
that's the thing. If you are not liable for the contractual relations, why do you check it? What you need is just to check the dates to understand if the player is an actively registered player with the other club or not. As an FA, why do you dive into into the relations between me and the player as a club, I speak? Because if there is a problem, then there is an independent disciplinary or appeal committee who will take care of that. If there is a employment relation dispute, there is an independent NDRC which must take care of that. So by this interference, I suppose there is also an intrusion into the independence of the judicial bodies of the committee of the FA. So I think
I agree with you. I totally agree with you, Ashok. And to be fair with the association here, they are not checking the legitimacy of the clauses. They are just checking to see that there are not any clauses which are contrary to the national regulations. For example, the duration, that it cannot be a contract of 6 or 7 years, or if it is a minor, it cannot be a contract
above 3 years,
more than 3.
Yeah. So very interesting, and obviously this conversation, this part is very, very interesting because we are from, let's say, two different sides. You have, let's say, player-oriented background, let's say,
Yeah.
and I have club-oriented background. So this is the like a classic clash between, two different associations, like representing the. I don't want to say me or you are biased or totally the opposite. I'm also an independent lawyer, so I represent players with clear mentality and stuff like that. We are not biased, but the background from when time comes for the regulatory matters, this always like rises up, this
For sure.
background rises up. So interesting, yes. So the fourth question is absolutely up to you, which you would like to discuss, and I will catch it up without any problem. So let's pick what you want to talk about the domestic regulations and domestic market. Can be NDRC, can be FFAR, can be disciplinary competition, whatever you want.
Well, we are having a huge disagreement with the clubs, and we are waiting for a CAS decision. We had the hearing about a month ago, so this decision of CAS will clarify things. Will clarify uh, a 4 to 5 year long dispute. For when we were preparing the standard contract, we inserted that clause which I described to you earlier, that in case of any dispute, the NDRC will have exclusive jurisdiction. Okay, so that was the clause inserted when the relations between the players' union and the association were good, because one of the things that we had agreed was to amend also the RSTP regulations of the NDRC so as to make it independent and impartial according to the FIFA regulations and have the competence to hear disputes of international dimension as well. So after 2020, when problems came up between the two sides, the players' union stopped its representation in the NDRC, and it's our position that the NDRC is not competent to hear employment and disputes of international dimension. FIFA has never disagreed with our side, the player side, so disputes with foreigners were always shaped and decided by FIFA. The association and the clubs are they are doing their best to keep even international dimension disputes in Cyprus. And the reason is because the Cyprus regulations give the debtor, which is always a club, almost always a club, then give them the right to pay off a decision over monthly installments. So they give them the right to pay over a time period of even more than 2 years. Whereas FIFA gives them the right to pay, FIFA orders them to pay within 45 days. Okay, so you can imagine the difference in these two regulations.
But in any case, the latest NDRC, according to the latest NDRC standard regulations, which FIFA published recently, relatively recently, the new mechanism says that NDRCs, if they want to take also the international dispute cases domestically, they must be, let's say, I don't want to say approved, but there is a
No, you said
requirement.
it correctly. They needed to file an application. I think the deadline ended in December. I'm not sure about this. They needed to file, no, not December, sorry, in June. They needed to file an application so that they will be examined by a special committee, a special body of the FIFA and DRC, which will decide if the national NDRC, if the NDRC is independent and impartial. And this decision cannot be appealed, and it's going to last time for a number of years. I don't remember how many years. Then the dispute that we had at CAS recently was before the implementation of these regulations, the NDRC principles. So it's not a decision of FIFA; it's a decision of CAS, and we are waiting to see what CAS is going to say on this part. Of course, when it comes to new disputes, then yes, there The question whether the NDRC is competent or not will be made only by this special body of the DRC, of the FIFA and DRC.
Yeah, let's see. If the CAS award is public, I will just kindly ask you to send it to me to have a look because it's interesting. The competence is always crucial point because sometimes if you do not study the root of remedy, let's say pretty deeply, you can just stuck at the middle of the road without any protection. And as you said, you can be at the moment when the prescription period is going to be over, and that's it. You just lost.
Yeah,
Yeah, so it's very interesting. Other topics from domestic market, FFAR, how the situation is with FFAR.
Most of the agents here do not register, to be honest. So the money is not declared. In the past, with the intermediary regulations, nothing was being declared. Everything was settled between clubs and intermediaries. We had a specificity that, for some reason, the association imposed a cap, a fee, a commission cap on 3%.
Service cap.
The service cap on 3%. So you can imagine. I mean, nobody wanted to. No agent wanted to show his commission agreement to the association because he would not be allowed to get more than 3%. So everything was agreed privately between clubs and agents without disclosing any information to the association. In very few cases was the association, disclosed and or notified about the two payments to intermediaries.
And is FFAR suspended locally?
They are suspended, or the provisions that have been decided by FIFA on the 30th of December.
No, I know the circular of FIFA, but is the suspension adopted by FIFA locally implemented or not? Because Yuri Zaitsev told a very interesting thing about Russia, that the Football Union of Russia didn't suspend the FFAR locally. So basically, they have a situation where if the transfer is concerned, if the transfer is related to international dimension, like they have some kind of a deviation because if there is an international transfer, FFAR is suspended, there is no service cap. But domestically, it's in force, and domestically there is a service cap with all the consequences thereof. So they have a little bit, let's say, different collisions of situations internationally and nationally in terms of transfers. And so what about Cyprus? Is it fully implemented, the suspension, or not?
To be honest with you, Ashot, in Cyprus, the FFAR have never been implemented anyway. There are no national regulations, so there's no.
So it's already suspended by default by being not implemented in currently. Yeah, so you see, you are in a step ahead of the regulations. Yeah. So any other matters you would like to say?
Well, something interesting about Cyprus is the fact that we are the first country globally in the number of non-national players.
What do you mean? Can you elaborate a little bit?
Yes, the number of players who are not Cypriot citizens, Cypriot nationals.
So most of the players are from abroad.
We are a small country, you can imagine. Our teams, they do relatively well in the European competitions compared to the size of the country. And this is because, following the Poznan decision and the prohibition of and distinction between nationals and EU nationals, the clubs have the right to register a big number of non-Cypriot players.
And what about the national team? Like I suppose in this case, there will be many cases when UEFA submits application to FIFA for naturalization of players in order to make them eligible to play in the national
Yes,
team or team representative. I mean, you know the regulations, right? Which I speak about.
yes, I know about the issue of naturalization of a player is a decision of the government, no, not FIFA. So, but our legislation it has an exception. I mean, it says that non-Cypriots can get the nationality of Cyprus if they live in Cyprus for at least 7 years. However, there is an exception that in cases which are considered as beneficial for the country and the public interest, the government, the ministerial council can give citizenship to people who were here, who were in Cyprus even less than 7 years. So it is unfortunately an often practice of the association to submit these kind of applications to the government.
Yeah,
And
because
they are
that's interesting. That's interesting because FIFA's regulations on the players' representation says 5 years of residency. This is
Yeah.
interesting. You say local one says 7 years, but the FIFA's one says 5 years. So it's also interesting deviation. Okay, I think it was very good, very interesting and substantial, let's say, conversation. So thanks for accepting the invitation and coming to have this comparative law. Let's call it comparative sports law or comparative football law. So once again, thank you and always being in touch as usual. And I suppose we can finalize for today.
Thank you for the invitation, Ashot. It was I was very happy to speak with you. And anything you need anytime, I am at your disposal.
Thank you very much for your kind words. So keeping in touch, take care and have a nice day.
You too, Ashot. Thank you very much. Bye bye.